Welcome. Today we're going to discuss important case law that impacts architects and engineers. To help us unpack these recent cases and extract lessons learned, attorney Jonathan Shoemaker with the law firm Lee Shoemaker in Washington, D.C. joins us. He's organized this presentation into several areas of importance, and within each will offer strategies to help you manage your risk. The areas he'll cover are duty to defend, duty or lack thereof to contractors, depending on exculpatory contract language, liquidated damages, statute of limitations, consequential damages, issues in construction administration, and finally, copyright. I'll go ahead and introduce our speaker. So Jonathan is a partner, as I said, at the law firm Lee Shoemaker in Washington, D.C. He concentrates his practice in the representation of design professionals involved in construction-related disputes throughout the Commonwealth of Virginia, Washington, D.C., and Maryland. With more than a decade of experience handling claims in the construction industry, Jonathan has tried cases before judges, juries, and arbitrators. In addition, Jonathan handles transactional matters on behalf of design professionals, from corporate structuring to risk management to advising on mergers and acquisitions, and is active in various design professional organizations. So with that introduction, I will now turn this over to our speaker.
Thank you, Yvonne. So every year we like to look back at the previous year's case decisions affecting architects and engineers so that we can understand what type of trends may be occurring across the country in order to take those lessons learned and incorporate those into the advice that we provide to our clients and to share our observations with them. This is a condensed version of that review focusing on what I believe are 8 of the most important decisions from the past year that hopefully will provide some lessons for you all that you can take away and learn from the experiences of others. So without further ado, we'll get into the actual presentation. The first topic is the duty to defend, and the case that we'll be talking about involves a nice small firm involved with a project for a public owner. And on this particular project, it was a bridge overpass project in the state of Maryland. The contractor on the project complained that there was a design deficiency in the design of the bridge, the pedestrian bridge, and that the owner should pay approximately $700,000 of additional costs in order to overcome the alleged design deficiency. Over the course of an extensive litigation process, which the court described as particularly acrimonious between the lawyers, there were arguments advanced on all parts of the dispute. But in essence, the contractor sued the owner, and the owner in turn sued the engineer who had designed the pedestrian bridge. And the owner demanded both defense and indemnity. And we have the language that was the basis of the owner's demand for a defense from the engineer up on the screen for you right now. In this particular case, the contractor's claims against the owner were dismissed without prejudice on the eve of trial, meaning that there was never any finding of liability against the engineer on a case that went to trial. But after the contractor's claims against the owner were dismissed without prejudice, the owner proceeded with their claim against the engineer for breach of the duty to defend. And I'm sure you've all heard about the scary ramifications of a duty to defend, that it's not covered under the terms of your policy. But this case provides a real-world example as to the true consequences of agreeing to that type of a risk. And in this particular case, the engineer had signed a basic ordering agreement with the owner that included the language in front of you. They subsequently entered into various task orders that were issued pursuant to the basic ordering agreement. And those task orders included indemnity language that did not include a duty to defend. And so the issue before the court was whether the duty to defend in the basic ordering agreement was remained in effect, or whether the inclusion of an indemnity provision in a task order superseded the duty to defend. And the court in the case said that the indemnity provision in the task order did not supersede the duty to defend, and as a result awarded attorney's fees in favor of the owner against the engineer in the amount of $350,000 of uninsurable risk, in addition to their own attorney's fees. So for a grand total, because there was this duty to defend, the engineer in this particular case became the de facto insurance carrier for the owner, even in a circumstance where there was no finding of fault or liability on the part of the engineer. And the really fun lesson to be learned from this is that as a result of the dismissal of the contractor's claims without prejudice, the contractor was allowed to refile the claims again in the future. And so while we don't have a published decision in the follow-on case, logic suggests that the engineer had the pleasure of paying the owner for additional attorney's fees on the subsequent lawsuit. So that's the outcome right there. The lesson to be learned really is that you should not be agreeing to defend your clients against lawsuits. Not only is it uninsurable, but it presents a situation where you can incur liability and loss and costs where there's no actual wrongful conduct on your part. So this is an excellent lesson learned in a case that illustrates what the real consequences are of agreeing to a duty to defend. Our next topic today is the concept of duty, and who does the design professional owe a duty to? We're going to head up to South Dakota to a project involving the Pine Ridge Indian Reservation. This was a road widening project where the contractor did not achieve substantial completion on schedule. There was no dispute about that. The contractor didn't complain that the owner was the cause of the delay. However, the contractor at the end of the project was assessed liquidated damages by the engineer in the amount of $103,000. This was a typical design bid build project, meaning that the owner contracted with the engineer and contracted separately with the contractor. And because the engineer had assessed liquidated damages against the contractor related to the delayed substantial completion of the project, the contractor did the most logical thing possible and sued the engineer, claiming $1.1 million of damages associated with the unfair and improper administration of the contract throughout the entire course, complaining about their interpretation of what was or was not included in the design documents. The contract between the owner and the contractor included the attached exculpatory provision related to the engineer's liability related to decisions made as the construction administrator of the construction contract. This language is fairly typical. I'm sure most of you have this type of language in your contract or something very similar to it. But in essence, it says that as long as the design professional exercises good faith in the administration of the contract, that there's not tort liability, meaning the liability outside of contractual lines of privity associated with the administration of the contract. In other words, you don't get to assert claims against the umpire because you don't like the way that they're calling balls and strikes, as long as they're being fair and impartial in their calling of those balls and strikes. And in this particular case, the trial court found that the exculpatory language in the contract did provide a defense to the engineer. The court specifically looked at the circumstances and said that all the contractor alleged was basic negligence, but that but that there was no evidence of intentionality on the part of the design professional to act with favoritism or preference in one way versus the other. And on appeal, that decision, based upon the contractual language, was affirmed. The lesson to be learned is, what do you include in your standard general conditions to manage the risk of claims brought by parties not in privity with you? Oftentimes, our clients have the opportunity to include standard terms and conditions in Division 1 of the specifications, or have an opportunity to review and comment on the proposed general conditions that the owner plans on incorporating into the construction contract. And it's important to keep in mind that those are opportunities for you to make sure that appropriate risk management provisions are included in the overall contract documents, and so those risks are accounted for on the project. The next topic we'll be talking about is liquidated damages. This particular case takes us up to Michigan, and it's a case involving the take the money and run contractor. Sometimes you really cannot make up the facts of a case better than they present themselves. This was a design build contract for a parking structure. The architect was a sub-consultant to the design build contractor, and throughout the course of the construction of the project, did sign the contractor's applications for payment. At the completion of the project, the design build contractor received payment from the owner, took the money, and elected not to pay their subcontractors, and suddenly disappeared. They wound down their business and they were no longer around. Moreover, the project was completed in a delayed manner, meaning that there were liquidated damages that the owner believed they were entitled to recover from this design build contractor who had disappeared. The architect's applications for payment that they had signed did not include any back charge or accounting for the liquidated damages, and did not account for or acknowledge in any way, shape, or form that the contractor had failed to pay their subcontractors. Although the architect was under contract with the design build contractor, because the design build contractor had disappeared, in essence, the owner filed a lawsuit against the architect, saying that the architect breached a duty owed to the owner as a result of its signing of an application for payment without notifying the owner of the appropriate amount of liquidated damages to be applied and set off against the application for payment, as well as without advising the owner that the contractor had not in fact paid all of their subcontractors. Seems like a fair allocation of risk, right? So in any event, the response from the architect was that, I don't know a duty to you related to these liquidated damages and related to the design build contractor's failure to pay its subcontractors. I don't have a contract with you. You didn't ask me to certify these payments. And in fact, my certification merely stated that the work that had been installed was in a manner consistent with the contract documents. Not that I've accounted for and allocated responsibility for liquidated damages, not that I've accounted for and determined and confirmed that the design build contractor had paid all of its subcontractors, and I just don't owe you a duty because I don't have a contract with you. And the application for payment doesn't say what you think it says. And the court fortunately agreed with the architect, finding that because they had contracted solely with the design builder, there was no contractual or common law duty owed to the owner to determine either the owner's entitlement to liquidated damages or to confirm that subcontractors had been paid. So this is a good outcome for the architect, but the real question is, what is the lesson that you can take away from this? And it's really that applications for payment are a risky proposition that oftentimes get overlooked by design professionals. They're seen as perfunctory. On some projects, it's not uncommon for the owner to handle the preliminary review in an effort to save money, and then once the preliminary review is complete, to turn over the application for payment for certification to the design professional. But the real question is, have you taken a look at what you're actually certifying, and who at your office is allowed to sign these applications for payment? Have they been to the site? Have they observed the progress of the work? Is all of the backup required by your specifications? You know, all of that good stuff that you included in Division 1, or that may be included in the construction contractor's contract, is that included? Is all that backup documentation included in the application for payment? Because if you haven't gone through the process of looking for that information, then you're creating potential exposure that somebody comes in after the fact and tries to Monday morning quarterback your judgment in approving the application for payment. And fortunately, there's typically liability that flows along lines of contractual privity related to this, but applications for payment can be provided to any number of people, whether it's the owner, their lender, and it just gives rise to risk to the design professional that somebody who doesn't have a contract with you is going to try to assert a claim against you in the future. Our next subject is the statute of limitations. This is a case in the District of Columbia. And let me start off, any conversation with respect to statute of limitations is going to vary from jurisdiction to jurisdiction. So you should absolutely talk with a lawyer in your particular state or jurisdiction about how the statute of limitations applies in your location. But one of the benefits of the District of Columbia as it relates to learning about the statute of limitations is that they apply both what's called the first breach rule as well as the discovery rule, and depending upon the circumstances. And those are the two different rules that get applied in most states. So it provides a really good opportunity to study the statute of limitations from a high level. So this particular project involved a $10 million tennis facility, and there are certain facts that are important for you to be aware of to understand the statute of limitations issues in this case. The design professional submitted a set of design documents for permit in October of 2011. The authority having jurisdiction issued a building permit for those design documents in March of 2012. Construction of the project proceeded between March of 2012 and November of 2012, when substantial completion was achieved. A couple years later, the owner sent some nastygrams to the design professional complaining about various issues with the design of the system, or the design of the facility. There was a mediation that took place in July of 2014, but for whatever reason, the owner never got around to filing a lawsuit until November 10th, 2015. The issue presented in the case was whether or not the court should apply the first breach rule, or whether or not the court should apply the discovery rule. The court, in considering this particular case and applying DC law, found that the first breach rule should apply. And the first breach rule basically says that the statute of limitations begins to run from the date of the first breach of the contract, even if the owner doesn't necessarily discover the breach until a later date and time. But the court went a little bit further than that here and said that, in essence, it's virtually impossible, even if we were to apply the discovery rule, for the owner to say that they didn't know about some of these alleged design issues prior to the substantial completion of the project. And importantly, substantial completion of the project was almost 3 years to the day prior to them filing the lawsuit. And the court said in essence, regardless of whether or not although we believe the first breach rule applies, regardless of whether we applied the first breach rule or the discovery rule, the outcome is the same, and that is that the owner did not file a lawsuit within 3 years of the breach occurring, the alleged breach occurring, or alternatively, the owner's discovery of the alleged breach. And so as a consequence, the entire case was tossed out. As one of the arguments that the owner advanced to try to avoid that result was that they had started mediation, they had started the dispute resolution proceedings in July of 2014, and so therefore that should stop the running of the statute of limitations. That's an argument we're seeing more and more frequently in all the jurisdictions we're appearing in, although we have yet to see a court agree with that type of concept for tolling the statute of limitations. The lesson to be learned is that the prudent design professional is better served by including a contractual statute of limitations provision, probably defining the accrual of a claim as no later than the substantial completion of the project, in an effort to avoid getting yourself into a fight that results in spending significant legal fees over when the statute of limitations begins to run. In those situations, I can assure you that nobody except for the lawyers wins. And if you're interested in some language, the AIA 1997 documents used to include such a statutory such a contractual statute of limitations provision, but it has been removed in the 2007 documents as well as the 2017 documents. So that's a good place for you to go and take a look at what I'm talking about as a contractual provision you may want to think about considering and including in your contracts to manage risk. The next topic we have to discuss today involves the concept of waivers of consequential damages. A waiver of consequential damages, I'm sure you've seen them in all of the AIA documents. They're included in the B101, they're included in the A201, and they're just generally recognized to be good provisions to have. But what is a consequential damage versus a direct damage? And what is the risk associated with providing construction administration services, or in the case that we have before us today, construction engineering inspection services? In this particular case down in Florida, the engineer was responsible for providing limited construction engineering inspection services. So they had on-site responsibilities to be there. The language in their contract described their responsibility as in part to supervise the contractor's work. Probably not the best contractual language from a risk management perspective, but nonetheless, they were out there and they were providing some level in theory of QA, QC. During the course of the project, the engineer failed to catch some defective subgrade preparation that occurred. And as a result, the runway, once it was completed, started to experience deterioration. When the owner asserted a claim against the engineer for failure to catch the contractor's failure to properly construct the subgrade, the engineer, argued that their contractual waiver of consequential damages provision barred the claim because the damages sought by the owner were consequential damages and not direct damages. I can tell you that this is a very interesting case because the engineer's argument was, in essence, look, it didn't matter whether or not I was supervising the contractor's work. The contractor knows how to properly prepare a subgrade, and if they failed to do so, they're directly responsible for that. And my failure to catch them is a down the road type damage, but that the fact that the contractor was the one responsible for constructing the subgrade properly makes them the one who is directly responsible for the consequences of their defective construction. And so therefore, any damage I could have caused would have been consequential. I'm sure that the owner heard that argument and thought that the import of the position taken by the engineer was that the engineer didn't have any liability whatsoever related to the failure to catch the improper subgrade preparation. The case went up on appeal to the Intermediate Court of Appeals in Florida, and the Intermediate Court of Appeals agreed with the engineer's argument as a preliminary matter, finding that, and I'm quoting here, the contractor could have completed the project without supervision from the engineer, and so therefore the contractor was responsible for the direct damages, and the engineer was responsible for the for merely consequential damages. And because there was a contractual provision in which the owner waived the right to recover consequential damages, the engineer could not be held liable for any of the damages that the owner was claiming. There's a little caveat to this case, and that is that the Intermediate Appellate Court thought that the issue was so novel and so interesting that they did something that appellate courts don't typically do. They certified the question to the highest court in Florida, saying, we think that this is an important issue for you to take up. And as of yet, we do not know whether or not the highest court in Florida intends to take up the question or not. But if they don't take up the question, then the intermediate court's decision becomes a final ruling. But the takeaway is not specifically tied to the outcome of this, how the appeal gets sorted out. But really the question is, what is the risk of providing construction engineering inspection services? What is the risk to a design professional who provides construction administration services and is out in the field and has an opportunity to observe the work, but doesn't catch something, perhaps because they don't see it, but nonetheless, the owner believes that it should have been caught. And I think if you, depending upon who the design professional is and depending upon the circumstances, you may get very different questions, but if you're, or answers to those questions. But especially if you're in the field of providing construction engineering inspection services, I would commend you to take a look at this case and perhaps track the outcome in the long term, because it really helps to potentially answer some questions about what the exposure is if you're going to be taking on this type of service, and what the risk is so that you can properly price the risk. Certainly talking with some engineering firms that I work with, the engineers believe that this is the correct outcome because they believe that the contractor is the one who's responsible for the quality of their construction and that they shouldn't be held responsible for the full cost of correcting improper construction that they failed to catch. But if the outcome were very different, perhaps they would price their work very differently. So it's something to think about. These construction engineering inspection services, we see them becoming more and more prevalent, especially on public projects. So as you're thinking about undertaking this work, it's important to understand what the risk is associated with doing that work. The next topic that we're going to be talking about is very similar, but it goes to the concept of construction administration. And this case is a doozy from a fact perspective. This takes us to Illinois, just outside of Chicago. The project involved a $32 million school renovation project. And it was a troubled project from the outset. Very early on, the owner terminated the general contractor for default. And the project was bonded, so the general contractor's surety took over the project. 2 years later, after the project was complete, the surety sued the owner, claiming that the owner had improperly withheld $2.2 million from the surety. And for what it's worth, the question about the completion date and when the project was substantially complete became the crux of the case and the major issue. When the surety sued the owner for $2.2 million, the owner counterclaimed against the surety, seeking to recover $15 million based upon a liquidated damages provision. The owner argued that the surety had delivered the project more than a year late, and they based their position on a standard certificate of substantial completion signed by their architect. The response from the surety to the owner was to challenge the reasonableness and the validity of the certificate of substantial completion provided by the owner's architect. And specifically, they challenged it because on this project, the architect, there were two really key facts that really suggested that perhaps the architect was not acting in good faith by issuing this certificate of substantial completion that served as the basis of the owner's $15 million counterclaim. The first was that a temporary certificate of occupancy had been issued for the project 26 months prior to the architect's certificate of substantial completion. This temporary certificate of occupancy, of course, allowed the owner to occupy the space. So in essence, the owner's complaint was, although I've been using the space for more than 2 years, the project was not substantially complete until a year after the substantial completion date. The bigger issue, and the more concerning one from my perspective, was that 19 months before the certificate of substantial completion was issued, on which the owner based its liquidated damages claim, 19 months earlier, the architect had signed a certificate of substantial completion that the owner provided to the state in order to obtain funding from the state that was conditioned upon the substantial completion of the project. Yes, you heard that correctly. The architect issued two different certificates of substantial completion, the first one 19 months earlier than the second one, and solely for the purpose of obtaining money on behalf of the owner. Whereas the second one was issued solely for the purpose of helping the owner put together a counterclaim for $15 million against the surety for delayed completion of the project. The outcome was that the court denied and rejected the owner's delay claim against the contractor, finding that the architect had acted with a bias for the owner in delaying the issuance of the final certificate of substantial completion for the actual project to the contractor, and based upon the temporary certificate of occupancy, as well as the certificate of substantial completion provided to the state in order to obtain funding to close out the project. The lesson to be learned, hopefully, should be obvious to you, but it's that design professionals must act in good faith to avoid having their decisions in the administration of a contract called into question. And in this particular situation, I'm not entirely sure what the outcome was for the architect after the fact, whether the owner had put two and two together and understood that they had requested, in essence, two different substantial completion certificates with two different dates, and whether the owner was complicit in this issue, or whether this was the architect going on a frolic and detour, trying to help out their owner, but not necessarily looking out for their best interest by allowing them to incur substantial costs pursuing a frivolous claim. The next topic that we will be covering today is a copyright related claim. And this is, I would say, my favorite case of the year. And you're probably looking at it, and if you can see the description of the case, you'll see that it's a trial decision, not an appellate decision. But this is the case that for me, from an educating my client's perspective, is the case that keeps on giving. Because we've been reviewing the earlier decisions in this case dating back to 2014. This is the third or fourth decision issued related to this one dispute. So I want to go back in time to sort of bring you up to speed, to have a better context for what we're talking about here. This particular case involves the development of a project in McLean, Virginia, just outside of Washington, D.C. The owner of the project had narrowed the field of prospective architects to three finalists. One of them was Humphreys and Partners out of Minnesota. One of them was Lessard out of Northern Virginia. And the third one was was also unsuccessful, but not involved in the case. During the course of the bidding process and the proposal process, the owner had shared with Lessard a design of a project in Minnesota that Humphreys and Partners had done that presumably they liked the aesthetic of. The top is the project in Minnesota. The bottom is the project that was ultimately designed by Lessard. Once the design was complete from Lessard, Humphreys, who was not selected to proceed with the project in McLean, filed a copyright infringement lawsuit against Lessard and the developer, claiming that they had violated Humphreys' copyright in the project that you see at the top in front of you. There was extensive litigation previously about this. The court went into both subjective and objective evaluations as to whether or not the two designs were substantially similar and for which there would be copyright protection. The outcome in the earlier decisions was that the two projects were not sufficiently similar enough to each other to provide for a copyright infringement claim, and there was no violation found. And there was, after the trial court's decision, which was issued following a year or two of discovery and significant attorney's fees, the case was appealed to the Fourth Circuit Court of Appeals, and that decision was affirmed. And what happened was that the case was sent back down to the trial court to discuss the attorney's fees issues. The attorney's fees for a copyright infringement case can be shifted at the discretion of the court. And in this particular situation, the trial court on remand decided that the developer and the architect were entitled to recover their reasonable attorney's fees based upon the lack of merit in the claim, but not just the lack of merit, but based upon the astronomical damages that were claimed by the Humphreys in relation to the relatively modest lost profit that Humphreys anticipated making in the event that they had been the successful bidder and allowed to proceed with the design of the project. In that particular case, the trial court received an application for attorney's fees from the developer, which after years of litigation totaled $990,000, and received an application for payment from the architect for their attorney's fees totaling $1.4 million. The trial court looked at those attorney's fees and reduced them based upon the court's evaluation of the reasonableness of those fees. And so for the developer, the trial court reduced the fees to $790,000 of the $990,000 sought. And for the architect, the court reduced the fees from $1.4 million down to $840,000. The insurance carrier for the developer, who had seen the court write down $200,000 of attorney's fees, then proceeded to file the case we're talking about today. And in this case, they sought to recover the $200,000 of attorney's fees that the trial court had written down, as well as a further $45,000 that they negotiated off with the claimant to avoid the cost of further appeals. So in essence, they filed a lawsuit against Lessard, the architect who had allegedly infringed on the contract, based upon the terms of a defense and indemnity type provision. And in that particular provision, it said that the architect would indemnify, defend, and hold the developer harmless from and against any and all losses, liabilities, expenses, claims, etc., including but not limited to reasonable attorney's fees relating to the services performed by the architect. So something incredibly broad, something we wouldn't, an indemnity provision we wouldn't recommend you sign, but that's what was presented to the court. And in this case, fortunately for the architect, there was a statute in Virginia that, based upon the breadth of this indemnity provision, the court concluded that the indemnity provision was unenforceable as a matter of law in Virginia. And so as a consequence, the court found that the entirety of the claim for attorney's fees should be dismissed. As it relates to the loss, and you want to put it into context, the claim related to against the architect resulted in the architect incurring $1.4 million in attorney's fees, of which the court only awarded $840,000. So they were out of pocket $550,000 of attorney's fees spent defending against this claim in the first instance, and then they were being asked to pay for an additional about $250,000. All of this, sort of being not related to anything that they did other than presumably follow the guidance provided by their client as to the aesthetic that the client liked, and incorporating the various elements that the owner was looking for in the case. And so as a consequence, the lesson that I take away from it is really, how fair is it for an owner to ask a design professional to assume a defense and indemnity obligation related to copyright claims? We often see in contracts that we're asked to review, owners bifurcate out or separate out indemnity provisions, one related to alleged professional negligence or wrongdoing on the part of a design professional, and a separate provision related to violations of copyright. And the owner's argument in that situation always tends to be, you know whether you're copying somebody else's work. You have the ability to say, to decide whether or not to copy somebody else's work. And so therefore, you should defend and indemnify me if you do in fact choose to copy somebody's work. But this case is an excellent example as to why it's unreasonable to make that ask of a design professional. And that is, there are times where the owner may say, I like this aesthetic. I like this element of this particular project. I want to see it woven into our project. And the design professional doesn't have a say in controlling that risk. Similarly, when you go through a design charrette, you may explore several different design aesthetics or options. The owner may provide sample boards saying, here's what I like, here's what I don't like. And in the underlying case we're talking about, the owner literally provided a copy of the Humphreys design to Lessard. We don't know what they said about it. It wasn't talked about in the case, but it's the type of information that was provided by the owner to the design professional, presumably so that the design professional could understand a particular element or feature that the owner was looking to incorporate into the final product. Of course, an individual element may not be subject to copyright protection. But so we have, because of the iterative nature of the design development process, have started asking owners counsel, how is it that you expect my client to understand and know about each and every design that has been incorporated or developed and built anywhere across the country? Because your client may look at a project out in Iowa that my client's never seen, doesn't know anything about, but based upon the feedback and desires expressed by your client, you could end up with a virtually identical building that could give rise to a copyright violation claim that the design professional knows nothing about. And so I think it's something that's really important to think about. When you get immersed in copyright claims, you're talking about hundreds of thousands of dollars, and there's a lot of uncertainty related to the costs and perhaps uninsurability related to fee shifting of those costs related to defense and indemnity provisions. So something to think about. The last case that we're going to be talking about today, not my favorite case, but perhaps the scariest case that we're going to talk about today. This case involves the Digital Millennium Copyright Act, which is different than the General Copyright Act that most claims by design professionals related to copyright infringement are brought under. In this particular case, the owner signed a contract with an original design firm, which included a design license agreement to utilize a basic design prepared by Preston Wood. It wasn't customized to a particular site. But it was a generic design, and the terms of the license agreement allowed them to do certain things, but perhaps not to do other things with the development of the design. After the design firm provided its work product of house designs to the developer under this license agreement, the developer provided those designs to a follow-on architect to develop permittable drawings for the development of a project. The architect on the project developed those designs, submitted them for permitting, and also developed renderings and worked with the owner to develop renderings that were ultimately used in the advertising of this project and sent out to between 8,000 and 15,000 people via blast email. Those blast emails that you love to receive in your inbox. Mm-hmm. The original architect who developed the design and provided it to the developer under the licensing agreement felt that the dissemination and use of its design had been, in fact, in violation of the Digital Millennium Copyright Act. And specifically, what they complained about was that the design had been used while removing the name and identifying information of Preston Wood, so that in essence they were no longer being provided credit for the original design that was further developed for application at the site. The Digital Millennium Copyright Act, which has typically never been, we've never seen it applied in relation to a design professional before, prohibits the removal of what's called copyright management information, which is the name and other identifying information that might be used to prepare a derivative element from a copyrightable product. And here, the removal of the name and the identifying information of Preston Wood would have taken place when a legend was removed, when logos were removed, and when attribution for the original design was not provided, either in the permit documents or in these 8,000 to 15,000 blast emails that were sent out showing renderings of the project. Under the Digital Millennium Copyright Act, there's a range of penalties that can be issued on a per violation basis. The lowest penalty being $2,500 per penalty. The case went to a jury trial in November of 2018, and the jury found that there were that there were 11,516 violations of the Digital Millennium Copyright Act based upon the blast emails. When you multiply that out, there was a finding and a judgment entered in the amount of $28,790,000 associated with the violation of the Copyright Act. The outcome of the case is that the trial court had rejected the argument advanced by the developer and the poor follow-on architect, who I assume was told by the owner that they had the right to use and develop these documents based upon a license agreement. But in essence, there was significant exposure to them associated with the fact that they had not included the original design firm's notices and legends in everything that they used to develop the design finally, as well as these blast emails. But this is the first case that we're aware of where the Digital Millennium Copyright Act has been applied and found to apply against as it relates to architectural works. Obviously, in the case, the architect and the owner argued that the Digital Millennium Copyright Act was not intended to apply to architectural works, and certainly not in this particular application, and so therefore the case should be set aside. It's anticipated from conversations with the trial attorneys that there will probably be some post-trial motions practice seeking to set aside the verdict because the Digital Millennium Copyright Act doesn't apply, is what we anticipate they'll be arguing. We also would anticipate that, given a $28.7 million verdict and the fact that there are not very many design professionals who carry liability coverage to that extent, seems likely that there would be some appeals. But the lesson to be learned is really that replicating copyrighted material without including attribution or appropriate attribution may constitute an independent violation of the Digital Millennium Copyright Act and can lead to extraordinary exposure for the design professional. Just as a practical risk management provision, anytime a client of ours comes and says we've been asked to take over a project from someone else, or we've been given some preliminary designs from someone else, we always encourage our clients to reach out to the design professional who developed those designs to make sure that there is in fact permission to use those designs and to either continue furthering the development of the design or to make sure that there's no interference with that design professional's rights under their contract with the owner who has been passing along their designs. And there's really a number of good reasons to do that. The lowest hanging fruit, of course, is that many professional ethics obligations, or many organizations such as the AAA, for example, impose that type of an obligation on their membership, that if you're going to take over someone else's work, you reach out to them to confirm that they in fact have the ability, that you do have the right to take their work product and further develop it. But more importantly, even if you have an owner who says, look, I'd be willing to defend and indemnify you if there's any issues associated with your use and development of these design documents. I'm not aware of too many owners who carry, $28 million in pocket change lying around to make sure that the architect is made whole in that situation. Nor am I aware of insurance programs that would be available to owners to provide that type of protection. So anytime you are asked to take over the work of someone else or complete their design work or make a derivative work of it, the prudent course of action is to always be on the lookout and speak with the design professional to make sure that they don't believe your involvement is going to create new exposure for yourself. Some people may think that this is a new business opportunity for architects, but of course, the representing design professionals as we do, my biggest concern is what is the risk and how can you manage it? And here, this is a risk that I just don't see you being able to manage in any way, shape, or form other than through direct communication with your predecessor designer. And with that, those are the 8 most significant cases of the year that we found from 2018, and hope you've been able to take away some lessons that you'll be able to apply to your own practice to safely manage risk and hopefully maximize your profits.
Great. Thank you, Jonathan. The information you shared, I know, had to have been extremely valuable to our attendees today. I'm sure they learned a lot, and we thank you for joining us today. What you're looking at right now, if you enjoyed this presentation and found it helpful to your practice and operations, and you are a Schnurr policyholder, this webinar, as I mentioned earlier, has been recorded. It will be available on demand for CE credit on the Schnurr School of Risk Management e-learning platform for others in your firm who might benefit. So for those who are not familiar, we created in late 2017 our new e-learning platform in recognition that design firms need CEs and you also need risk management education. So we combined the two needs and we created this new platform so that you can access courses, a curriculum. We have a role-based curriculum or several. You can take quizzes and it's all on demand 24/7. It's all part of the value of being part of our program. No additional fees involved at all. Our goal in developing this is to help design firms have easy access to on-demand risk management courses to help them mitigate risk and stay informed of the latest and important industry trends. As of today, we have 36 other courses available for design professionals on various relevant risk management topics, both project-specific and operational risk-related. And as I mentioned earlier, we also have a role-based curriculum within the school that may be of interest. We also have the library of written guides, resources to help you and your firm and colleagues stay on top of best practices, whether it's contract issues, technology, marketing, staffing, and HR issues, and a host of many, many other issues. So with that, thank you again for joining us today. Please do expect a survey coming to your email inbox soon, in which we will ask you questions for feedback and also questions regarding getting CE processed, and we'll be happy to do that for our policyholders. If you are a Schnurr policyholder, there will be a specific question within the survey that you receive, and all you have to do is say, yes, I would like CE credit processed for me, and we'll get that done for you. So that concludes today's webinar. We hope you enjoyed it, and have a nice day.